Have you ever wondered how land in Malaysia could be transferred? Is it like as easy as gifting a land to a person, or is it just like you give away a land? Well, actually, Malaysia has a very detailed and strict process on land transfer. So now let's all go through the understanding of land transfer on what and how to transfer the land. There will be two important issues that we will discuss here today, which is issues pertaining to what can be transferred in the concept of land, and also issues regarding the process of land transfer, especially due to the administrative fragmentation, legal restriction on land transfer rights, complication from informal hibah practices among Muslims, and also public misunderstandings of organisation policies. Before we discuss further into this topic, it is important to first understand the statutory provisions applicable. So, Section 205, Clause 1 of National Land Code 1965 mentioned that only the dealings outlined in Parts 14 to Part 17 of this Act could be conducted upon the alienated land, and transfer is one of the dealings. Section 214 of Clause 1 of National Land Code is on regards of what could be transferred, the types of the transfer. So, what can be transferred is the entirety of the land but not a fractional part of any alienated land or any undivided share therein. And second, any leasehold interest in alienated land and any charge over alienated land or its leasehold interest, and also any tenancy that is exempt from registration. Moving on to the procedure of the land transfer, Section 215, Clause 1 and Clause 2 of National Land Code mention that the transfer shall be executed using an instrument in Form 14A, and once the mandatory procedures relating to the form and registration have been complied with, the title of the transfer shall be passed to the transferee upon registration of such transfer, as well as the benefit of any such registered interest upon the land.
Okay, so now I'm going to present about a case that shows what can be transferred. So in the case of Peter Lai Kichin and collector of stamp duties, in this case, a man wanted to give half of his lands to his wife, but Section 214 subsection 1A says that no transferring part of the land unless properly subdivided. So in this case, the claimant, the husband, he transferred the whole land to himself and his wife as co-owners, and that shows that this is legal, and that shows that the land can be transferred to ourselves with a co-owners, which shows that even if you want to give half the land, you still can put your wife as the co-owner of the land. So it does not violate Section 214, subsection 1A. That's all from me. Thank you.
Okay, next we will discuss about the issue regarding the transfer of the land. In the case Manilal and Son and Pentadbir Tanah Daerah Kulim, is that under Section 322 subsection 2 paragraph C of the National Land Code, land cannot be transferred while a valid private caveat exists. Additionally, Section 215 subsection 2 requires that Form 14A must be properly completed and executed, while existing interest must be clear before lawful registration can occur.
So now we will see the transferable interest and legal limitation. What can be transferred and what cannot. So for the transferable interest, only registered interest, example like ownership titles or registered leases, are legally enforceable against the third parties. And National Land Code itself requires registration for a land interest to be legally valid. And moreover, there is also undivided shares, such as co-ownership between spouses, are also transferable as long as the entire land parcel is involved and not physically subdivided. Next, moving on to the legal limitation, whereby there is 4 issues as follows. The unregistered or oral leases are not enforceable against subsequent purchaser. Next, Malay reserve land may only be transferred to Malays, which restricting transferability based on ethnicity. And FELDA and group settlement schemes impose statutory restriction on land transfer, particularly for unpaid or non-registered lots. And there is also hibah, which is Islamic gifts, must be properly registered using Form 14A to be legally recognized. Informal or undocumented hibah may lead to a dispute among heirs.
Let's move on to how transfers work and the practical challenges in Malaysia. For the legal procedure, land transfers must first be executed using Form 14A as required under Section 13 of the National Land Code, and the transfer only becomes legally effective under Section 340 upon the registration at the Land Office, which protect the registered owner's legal rights. And for the challenges, public misunderstanding of initiatives like PMT One Hari has led to confusion because many people believe that the initiative guarantees same-day ownership transfer when in reality it only speeds up documentation, not final registration. And land is under state jurisdiction, despite the NLC being a federal law. So this results in inconsistent procedures and adoption of digital systems such as e-cadastre and e-tanah. And fraudulent transfers also remains a concern because although the federal court corrected the flawed principle in the case of Tan Ying Hong of immediate indivisibility, enforcement remains weak due to the administrative inefficiencies and lack of verification capacity. So these issues point to the need of a harmonized, transparent, and integrated land governance system in Malaysia.
The torrent system in Malaysia provides an effective structure to regulate land transfer. Its primary advantage is the certainty offered to registered landowner. Once registered, the ownership is indivisible, subject to certain exceptions under Section 340 of the National Land Code. The advantage of the system include clarity and security, where land title are conclusive evidence of the ownership. This reduces dispute and promote confidence in land dealing. Second, fraud prevention. The requirement for registration and state authority approval in dealings such as transfer or charge help prevent fraudulent transaction. However, there are also some weaknesses. The first one is delay. The process of transferring land can be slow, especially in states that still rely on manual filing system rather than electronic platform. The second one is special category of land. For example, Malay Reserve land and Felda land are subject to additional restriction, limiting who can own or transfer this land. This can complicate transaction and discourage potential purchaser. Lastly, unregistered hibah. Many Muslims do not formally register hibah transfer, which may result in dispute among heirs when the donor pass away, as the transfer may not be legally recognized under the land office system. We believe that Malaysia must fully implement the e-tanah system nationwide to speed up the registration process, reduce paperwork and minimize human error or manipulation. Digitalization will make land transfer more efficient and transparent. Additionally, the legal provision concerning Malay Reserve land and hibah transfer should be reviewed and updated. So there need to be a better public awareness and simpler procedure for registering hibah to prevent dispute. Clearer guidelines and state intervention are necessary to protect owner while preserving the intent of such transfer.
So it could be concluded that the land transfer in Malaysia is a very complicated legal and administrative process that is essential to guaranteeing the security and the certainty of land ownership. Although these measures are intended to protect the particular groups, they may also unintentionally hinder competitiveness and maintain inequality within the society. So it is suggested for the government to prioritize the nationwide implementation of digital land administration system, which is e-tanah platform, to facilitate online submission of documents, status tracking, and also communication with the land office. By digitalization, it could reduce human error, minimize bureaucratic delays, and also enhance transparency in the registration and transfer process. Next, we suggest that the legislature provide clearer definitions and streamline procedures for the exceptional cases to combat the ambiguities in the NLC, especially regarding to the restrictions on transfer, specifically pertaining the Malay Reserve land, virgin ownership, and also partial transfer. With this harmonization, it will reduce the inconsistencies and legal uncertainty, as per mentioned in the case of Peter Lai Chin and another versus collector of stamp duty. That's all. Thank you.